we have two cases. The suit number 562/2015 and the other one, which is against the First Bank.
Okay, yes. I'm for the one against First Bank. I represent First Bank.
Okay, but you are not in this matter. You are not in the matter.
No, my lord.
Involving Nigeria.
No, he's not in 562, my lord.
I'm not in 562, my lord.
Okay.
Yes.
Okay.
So I was surprised when my learned friend mentioned that we are together.
Okay. Let me. Okay. Yes, Mr. Chukuma.
Yes, my lord. I appear for the defendant. The defendant is unavoidably absent. An agent of the defendant.
Yes. Yes, Mr. Chukuma, the matter is for adoption of final written addresses.
Yes, my lord, and we're ready.
But your filing motion?
Yes, we have an application for extension of time to regularize our final address, my lord.
Okay. Mr. Chief, you are ready?
Yes, my lord.
Okay.
We are not opposing the application, my lord.
Okay, thank you. Yes, Mr. Chukuma.
My lord, the application is dated the 3rd day of February 2023 and filed on the 8th day of February 2023. Dated 3/2/23 and filed 8th day of February 2023.
Okay.
My lord, in the absence of any opposition, may I respectfully move in terms and urge my lord to grant the application.
Okay.
Most obliged, my lord. My lord, I'm very grateful.
Thank you. So defendant's application for extension of time to file its final written address dated 3rd February 2023, but filed on the 8th February 2023 is granted as spread.
As God pleases.
God
we are very grateful.
Yes, Mr. Chukuma.
Yes, my lord. The defendant's final address.
Yes.
Is dated the 3rd day of February 2023.
Yes.
And filed on the 8th day of February 2023.
Okay.
My lord, we most respectfully adopt the said final written address and deemed, the defendant's final address is dated the 3rd day of February 2023, filed 8/2/2023, and deemed properly filed today, my lord.
Okay.
Deemed properly filed today, my lord, yes.
Yes.
We most respectfully adopt the said final address and to urge your lordship to dismiss the suit for being premature and incredible, and to hold that in light of the evidence before the court, that the summary dismissal.
Okay, for being premature and
Yes, my lord. And to hold.
Yes.
in light of the evidence placed before the court that the summary dismissal of the claimants by the defendants is in substantial compliance with the defendant's staff conditions of service.
Okay.
Yes, my lord. My lord, we are very grateful.
But Mr. Chikuma,
Yes, my lord.
she said that she requested to defer her.
My lord, no evidence of that nature is before the court.
No,
Her exhibit. Yes, my lord.
Yes, her exhibit what? Her exhibit. I can hear you.
Her exhibit, I believe it's N9.
Which is what?
They purported this thing, never mentioned any deferred leave. The purported document that she's relying on did not make any reference to any deferred leave. Rather, she was applying for her 2014 leave and not the 2013.
But Mr.
Hello?
No, I'm coming, Mr. Chukuma.
Yes, my lord.
It's like there was an application reaching to her, reaching to you by the claimant, requesting to defer her.
It's not before my lord.
And from the conditions of service, it is stated that one can ask to defer his,
Yes, my lord.
Yes, there's nothing wrong with that for one to ask to defer his. Yes. So how can you dismiss somebody who has asked to defer his annual?
That's the point, my lord. The purported deferment which is relying on. We're not saying that the provisions of the staff conditions of service clearly states that leave will be granted annually.
Yes.
To employees.
Yes.
Yes, my lord. And they said that they should exhaust that leave within 30 calendar days of that year. And once it exceeds 1st February of the following year, it is deemed forfeited.
No.
If my lord looks at that document.
No, there is something that was said that was stated at the tail end of that provision of the.
Yes, my lord. Management may, with the consent of an employee, commence or defer the leave, but it should not be for more than 1 year. Yes, my lord. And the application she made was not asking for her deferred leave. She was asking for her 2014 leave. And it was made after the expiration of the 2013.
No, but this is what you said on Exhibit 9.
Yes, my lord.
He said, please note that your request to proceed for 2023 annual leave is declined. And this was signed on 26th of November 2014.
Exactly, my lord. And that is what she is claiming to be the deferred leave that she was applying for. When she did not make that application before, if you don't make it application before the 1st of February 2014, is deemed forfeited.
Then did you, Mr. Chukuma, did you communicate to her that her request for the deferment was declined? Did you communicate to her?
That is the point. She did not make any application for deferment.
Okay. Even at that,
application.
Yes, even at that, the minute you made on the 26th of November 2014, which is saying that her request to proceed for 2023 annual leave was declined.
Yes.
That information was that information. It was the claimant informed about that information, because from the questions answered during cross-examination, the witness said, no, I don't know whether the claimant was notified that her request for the deferred 2023 annual leave was declined. So what I'm trying to ask is that even your witness said that he doesn't know whether the claimant was notified that her request was declined.
Yes, my lord.
So what I'm trying to say that when it was declined, did you notify the claimant? The answer is no, isn't it?
No, the documents is there
No, but
showing
you're
that it was declined, because every
Yeah.
communication between the claimant and the defendant is in writing, official correspondence in writing. It's on there that your application is declined.
And Mr. Chukuma,
And
during
that is
that
our
time,
document. That is our document.
which
So how
one?
can she
The
say,
exhibit 9?
yes, it's a document. So how can she say she was not informed?
No, it's that no. What I'm trying to say is that the exhibit 9 is written by the claimant on the 11th of November 2014.
Yes,
The
Lord.
subject of the document says request for my 2023 annual leave. It says the
Yes,
above
Lord.
subject refers. I wish to apply for my 2023 annual leave, which I wish to start from Tuesday, 18th
Yes,
November 2014. Submitted for your approval, sir.
Yes,
Then
Lord.
it went to the, I think, number A, DFA. Says, sir, above
Yes,
subject matter and attached refers from the extract of NCAS condition of service, the officer has forfeited her annual leave. Number 3, submitted for your further directive, sir. Then signed on the 25th of November 2014. Then it was minuted to GMF. He said, please communicate to the officer in paragraph 2 above and accordingly. This was on the 26th of November. Then on the 26th, somebody AC, GMF addressed the letter, minuted the letter to, the document to ACA SAL.
Yes, my Lord.
Please refer to the attached extract of NCCA's course as it applies to annual leave and DFA's minutes in B and be guided accordingly. Please note that. Okay, so this was minuted to the claimant. Please note that your request to proceed for 2023 annual leave is declined.
Yes, my Lord.
It was signed on the 26th of November 2014. It said that it declined. Then when and you issued a query to her on the 27th of November 20. The following day, isn't it?
Yes, my Lord.
You issued the query to her the following day, isn't it?
Yes, my Lord. But my Lord
her letter was written on the 11th of November. Mr. Chukuma.
Yes, my Lord.
Her request was written on the 11th of November 2014.
Yes, my Lord.
That is at least 1 week to the commencement of the leave.
Yes, my Lord.
Because the leave was to commence on the 18th of November 2014, and she wrote the letter on the 11th of November.
No, my Lord. That is where the
That
is where the yes, my Lord. On the 11th of November, my Lord.
She submitted the letter. On the 11th of November, she submitted the letter.
Yes, my Lord.
Then, and informing you that her leave was going to commence on the 18th of November.
Yes, my Lord.
Then it was on the 26th of November that the GMF.
Yes, my Lord.
Sent a minute to her saying that her request was declined.
Yes, my Lord.
That's about 2 weeks.
Yes, my Lord.
Yes. So I thought the minute stating that her request was declined should have been made before she even commenced the leave, isn't it?
That is what we are saying, my Lord, that she absconded. My Lord, the point is we had a redeployment on the 11th of November.
Yes.
Seeing that she was redeployed on that same day to a place she felt was a demotion. She now wrote that letter saying that she is embarking on her deferred leave, which by the rules has been deemed forfeited. And it says the management may, having not taken the 2013 leave, which was supposed to expire by 1st February 2014.
Mm.
She only comes after her redeployment in November 2014 to say she's embarking on that and just handed over to the RRMCC on the 17th and absconded. We didn't see her again, my lord.
But are you charging her for abscondment or for absenteeism?
Leave without approval. Leave without approval.
No, okay. I mean for refusing to be deployed or
Yes,
for
and to stay at her duty post. She just submitted that letter purporting it to be an application for the Fed without waiting for an approval.
okay.
Without waiting for an approval, we didn't see her again, my lord. That is where the issue of query came. Because
okay, then if that's the case, what will happen to the exhibit 5A and B, which says which is the approval given to the claimant to travel to Israel? Exhibit I think it's exhibit 56 or exhibit 5A and B. Which was the approval given to the claimant to travel to Israel?
On what day, my lord? My lord, I'm so sorry. I am out of town. The file is not with me. I'm using soft copies. If my lord would graciously refer me.
No, but that issue of giving the claimant the approval to travel to Israel, I think you are aware, of that issue, isn't it? During that time, she was given approval to travel to Israel.
Not during that time. I believe not during that time, my lord.
Okay, during what time?
I don't have my file with me. I'm so sorry. I have only soft copies that I'm making use of. And I believe the purported tickets and emails, like my lord, we objected to them saying that they did not comply with section 84. And we said that AN 33 and 37 are inadmissible, being foreign documents and not translated to the language of the courts. They were made in Turkish language and all.
But in those documents, Mr. Chukuma, there are some words in English language in the tickets. There are some words that are in English language. Not everything that is in foreign language.
My lord cannot pick and choose, my lord.
No, it's
the
not
ones
everything
that are foreign. It's not the language of the courts.
Mr. Chukuma, this is the document now. Let me read from you. It's
yes,
saying departure Lagos Murtala Mohammed International Airport, Terminal 1, International Terminal, Istanbul, flight booking, reserve confirm, economy. So can the court look at the document and see from it which one is written in English language?
Yes, my lord.
It's not everything that's written in foreign language in those documents. There are some things that are written in English language. And can the court look at the documents and read from it?
Yes,
Mr. Chukuma, not everything that's written in foreign language.
I'm so sorry, my lord. My lord, I've explained my handicap as to my not
Mr.
to do with the file because I traveled.
There is exhibit AAN 6A and A to F.
Yes, my lord.
A to F, which says it's dated 3rd November 2014.
Yes, my lord.
It's headed Nigerian Christian Pilgrim Commission. Request for issuance of appropriate group entry visas for 2024 Christian pilgrimage Israel.
Yes, my lord.
I'm directed to forward here with the request for the issuance of appropriate multiple group visas in favor of NCPC Abuja, NCAA 019. They'll be traveling to Israel from the 12th to 23rd of November for pilgrimage.
2014. Is it 2014, my lord?
Yes, 2014.
Yes, my lord.
While thanking you for your cooperation, please accept the assurances of the Executive Secretary's highest esteem and consideration.
Yes, my lord.
This was written by the
Christian
the
pilgrimage.
head operations for the secretary of the Nigerian Christian Pilgrim Commission.
Yes, my lord.
That is to okay, I think to Israel embassy, I think.
Yes, my lord.
And so and some things were attached, and the tickets, the e-tickets, and some other things. What I'm trying to say is that so my question is that it is the claimant, so the defendant was aware that the claimant would be traveling for pilgrimage, isn't it?
No, my lord.
And it was during that, that leave period.
No, my lord.
Okay.
My lord, the documents she put in were
Yes.
vehemently objected to. Even the tickets, there is nothing to show that she actually embarked on that Israel trip. Even on her pleadings, she never said she embarked on the Israel trip. Because it would have been the defendants that would have paid for that trip. There is nothing to show that she embarked on that trip as an agent of the defendant.
My
It's
lord,
just a red herring, a deliberate
my lord,
ploy to excuse
my lord.
herself.
I'll come to you, Mr. Paul. I will come to you. You'll have the time
Just
to.
a deliberate ploy for her to excuse herself.
It's okay, my
There's
lord.
nothing before the court that shows that she embarked on that trip.
Okay.
Nothing.
Okay. Okay. It's okay, Mr. Chukuma.
Most obliged. My lord, I most respectfully thank you for the audience.
Thank you.
Very, very grateful, my lord.
Thank you.
Thank
Yes,
you.
Mr. Paul.
Yes, my lord.
Yes.
My lord, the claimant final written address is dated 6th March 2023
Yes.
and filed on the 7th March 2023
6 March 2023.
and filed 7th March 2023.
Yes.
We adopt same
Yes.
as the claimant final written address in this matter. My lord,
Yes.
the claimant was dismissed for two main reasons.
Yes.
One was the issue of refusal to proceed on transfer, my lord.
Yes.
And the handbook provision, my lord,
Yes.
provide specifically
Yes.
under paragraph 431 of the
Yes.
handbook
Yes.
that the punishment for such is termination and retirement.
Paragraph 4 what?
4.3.1
Okay.
of the handbook.
Yes.
There is no provision for dismissal.
Okay. 4.3.
1. 4
What is the
dot, 3 dots, and 1 dot. That is
one I
paragraph
have here?
4.
Then misconduct means any specific act or conduct contrary to the provisions of these conditions of service and or any act of wrongdoing which is inimical to the image of the authority and which can be investigated and proved. It can lead to termination and retirement.
Yes,
Is that what you are referring to?
Yes, let me check 4. I'm coming, my lord. I'm opening to the paragraph.
Yes. 4.3.1 is on definition of misconduct. Then 4.
Yeah, that 4.31 is on the definition.
Yeah, definition is.
Yes. Then you have types of misconduct.
Yes.
And under that, you have paragraph 4.3.2.3.
Refusal to proceed on transfer or to accept posting.
Yes, my lord.
Yes.
So,
and that one, then what? You are saying that if somebody refuses to be transferred, the punishment is termination, not dismissal.
yeah, termination and dismissal is classified as misconduct under that paragraph 4.31.
Yeah, what I'm saying is that the punishment would be termination, not dismissal.
Yes, my lord. Yes, my lord.
If it is just one's refusal to go on posting.
Yes, my lord.
Okay.
Then the second.
I'm so sorry, my lord. I'm so sorry, my lord.
I didn't interject you when you were talking. Allow me to run my presentation.
Sorry. Okay, so sorry. Go ahead, sir. So sorry. I apologize.
It's okay.
Yes, Mr. Paul.
The second reason, my lord.
Which is absence from duty without leave.
Yes, my lord.
Yes,
the evidence before this court.
It's under serious misconduct.
Yes,
4.3. 0.2.3.
4.4.2.3.
Yes.
That is where the defendant sought refuge to dismiss the claimant.
Yes.
And my lord, the evidence before the court.
Yes.
Indicates.
Yes.
That there was an approved leave.
Yes.
And the defense witness confirmed that leave was never exhausted by the claimant.
Yes.
And furthermore, my lord, the claimant.
That is the initial 2023 leave.
2030
leave. Yes.
Yes, my lord.
Yes.
Subsequently, my lord,
the
claimant wrote.
Yes.
Notify the defendant.
Yes.
That she will be going on that deferred leave.
Yes.
And that letter was circulated. The memo was circulated.
The letter
was a memo.
It's of 11th November 2014.
Yes, my lord.
Yes.
And several comments were made.
Yes, on the letter.
On the letter.
Yes, minutes.
And there was no communication of any kind before the exit date indicated by the claimant that she will not be allowed to proceed on that leave.
Okay, but Mr. Paul, shall I ask you?
Yes, my lord.
As an employee, do you have to wait until your request is approved, or just immediately after writing a request to go for your leave, just go without even waiting to hear from the employer whether it's approved or declined?
Well, that is a pertinent question.
Yes,
the main thing, my lord.
Because I think the ideal thing is that when you make any request or application, you have to wait, for either the approval or refusal of, of that request first before you even, embark on going on that leave.
Yes, my lord, that is to the extent that there was no approved leave previously. There is a leave already approved, leave period already approved for the claimant to proceed on leave.
Okay,
which
if
she
there
has
was
already started.
okay, if there was an approved leave already, why should she make the second request? If there was an approved leave or leave already, she should have just gone without even making the second request from the defendant.
Well, my lord, maybe at the risk of surplusage.
Why should she have to write for the second time? Because she needs the approval of the defendant, isn't it? And she went before that approval, because from that exhibit AA9, that is the internal memo of 11th of November 2014. There is a minute addressed to the claimant on the 26th of November saying that her request to proceed for 2023 leave is declined. It's stated there. Please note that your request to proceed for 2023 annual leave is declined. So with this, don't you think that the claimant has no basis to, proceed for her 2023 or for her request of the annual leave until the request is either approved or declined, but it's approved by the defendant? Can somebody just write and go, Mr. Paul? Can somebody just write and go, thinking that taking the request for granted?
Yes, my lord. I think if His Lordship has a look at the pleadings before she even put in that letter, yes, the claimant went to her immediate boss, who said that there was no need for that letter, but at the risk of surplusage,
okay, why is that
she decided to write.
Why is that
to put it on record? Because there is already a subsisting leave. If there was no leave at all, it's a different thing.
In which paragraph is that stated that she went to her boss and he said there was no need for her to?
Let me. I don't. Maybe I will come back to that, my lord. But let me run the full course of the of my adumbration, my lord. Then, my lord, the defendant said.
Okay, just hold on a moment. So you said that in your pleadings, the claimant's boss stated that there was no need for, for the letter requesting to proceed, because there was already an existing leave, isn't it?
Yeah.
Okay, yes, you can go.
Yeah. Then, my lord, assuming but without conceding that the claimant abandoned her duties. Duty, yes.
Yes.
Paragraph 41 of the defendant's statement of defense.
Yes.
The defendant
Yes.
said that the salary for the period that is from January to April 2015, 4 months salaries
Yes.
were deducted
Yes.
from the claimant.
Yes.
And the reason being that the claimant cannot be expected to be paid for that period because she was not on duty.
Yes.
And we also pleaded in the witness statement dated 18th June 2021
Yes.
of one Mrs. Abimbola,
Yes.
who absconded from duty for the
Yes.
period 2nd February 2015 to 27th May
Yes.
2015.
Yes.
The salaries for the period
Yes.
were also recovered from that staff.
Yes.
And the defense witness under cross-examination, my lord, confirmed that Abimbola was never dismissed.
Dismissed. Yes.
So to that extent, my lord, the Constitution forbids an individual from to suffer double jeopardy.
But that was provided for in the defendant's condition of service. I think
Yes, my lord.
It's provided for there that when somebody absconds, his salary for that period will not be paid to him, and he will be disciplinary action will also be taken against him. I think it was it's provided for under in the defendant condition of service.
Yeah, I saw it, my lord. But the Constitution is the ground now, my lord.
Well, what did the Constitution say?
An individual cannot be made to suffer any double punishment for an offense. You can only be, just as they did with regards to Abimbola, they recovered the period she was not on duty, they recovered the salaries, and she was never dismissed, my lord.
Okay, if supposing somebody steals his employer's property, can that person be disciplined by the employer and simultaneously be taken to court for prosecution in respect of a criminal offense? Can that happen?
It can happen.
If somebody steals from his employer,
yes,
can his
lord.
employer take disciplinary action against that person to dismiss him and at the same time take him to court for criminal prosecution?
Yes, my lord. We have the the case of Arinze and First Bank.
Yes, so it means that can happen.
Where, yeah.
It can happen.
But in that case,
yes.
In that case, my lord.
If that scenario can happen, then why not this case? it's already provided for in the conditions of service that when somebody absents himself from duty, the money he wasn't around, given to him, for the period that he wasn't around can be recovered. And disciplinary action can also be taken against him. What's wrong with that, Mr. Paul?
Yes, my lord. An employer
Yes.
has the option to, the employer has the power to discipline an erring employee.
Yes.
And recovery of money already
Yes.
paid,
Yes.
strictly speaking, would have been classified as already earned income,
Okay.
which, if it's recovered, will violate ILO Convention 95.
Okay. Which says
We state that more income or wages already earned cannot be deducted from the employee.
okay, even if it was illegally.
Well, such deductions under the Labor Act are supposed to be effected with the approval of an approved labor officer.
My lord, so sorry. My lord, so sorry. I've been.
Allow me to finish.
My lord, this is
Just
real litigation. This is not an
Mr.
adumbration, my
just
lord.
take note of
It is not contained in his. It's not contained in his final address, my lord.
It doesn't matter. Take note of
This is
of all the things that
the
you
claimant
do.
trying to relitigate his case.
No, but he in his address he has cited some ILO conventions. I can remember that.
As God pleases.
Yes, he has cited some ILO conventions. Yes, yes, Mr. Chief Paul.
Yeah, so my lord, to that extent,
Yes.
the said deductions,
Yes.
we humbly submit, we amount to double punishment.
Okay, okay.
Because the wages of an employee is guided jealously under the law.
Okay, okay.
And the employer cannot, through internal means or regulation, abridge the position of the law, my lord.
Okay, okay.
Yeah.
Okay. Is that all, Mr.
Yes, my lord. The other issue of not being efficient and all that, you discover that during this period, the claimant was also invited for promotion interviews.
Yes.
And to that extent, you don't invite an absconding staff to promotion interview.
During what time?
Hello, my lord.
During what time was she to the interview?
I don't have the actual date, but it's in evidence, my lord. That interview document.
Okay, was it after her dismissal?
No, it was not after dismissal. It was before the dismissal, my lord.
Okay. During the period of leave or what?
It was during that period of classified, which was classified as unauthorized absence, my lord. And that is the period we still have the pilgrimage to Israel. They are on record, my lord.
But even if somebody is on leave, can't he be invited for an interview, for a promotion interview?
Yeah, you can, my lord.
So what does that? Yes.
If the position of the employer, the defendant, is that the employee absconded, we didn't see her.
Yes.
There is evidence before the court that she was in the office to apply for the 2014 annual leave, and it was duly acknowledged by the defendant. So what we are trying to emphasize, my lord, the claimant was within this period all along available. She never absconded. The aforementioned, my lord, we humbly urge this court to grant all the claimants relief in this
She was
suit.
available. Mr. Paul,
Yes, my lord.
I said, can you hear me?
Hello? Hello, my lord? Hello?
I can
Hello?
hear you.
Yeah, I can hear you, my lord.
You are saying that the claimant was available.
Yes, my lord.
So if she were available, why does she, have to make the request to proceed on a leave? If she were available.
No, my lord, availability is qualified in this sense.
Okay.
What the defendant said is that the claimant was not available. They could not locate her. She absconded. She was in the office to receive letters following a text message sent to her by the boss. At that time, material time, she was available. So the issue of absconding, I think, is an overstatement calculated to classify the claimant as a fleeing employee that cannot be reached. So we urge his lordship to grant the claimant's relief in this and discountenance the defenses of the defendant. With substantial cost, man.
Thank you.
We are most grateful.
Yeah. Thank you. Then, Mr. Paul, this issue of a member of the claimants union was not part of the committee, of the disciplinary committee.
Yes, my lord.
You have raised that issue that
I raised it
the claimant belonged
both in our pleadings and the final address, my lord.
Yes, that the claimant the claimant belonged to a different union, and the person that participated in the disciplinary committee was a member of another union, and you are saying that the constitution of the of the committee breaches the defendant's condition of service.
Yes, my lord.
Is that not an irregularity? Once whoever participated in the disciplinary committee, once the claimant was given fair hearing and she was availed the opportunity to defend herself, can that thing be regarded as an irregularity?
My lord, is very fundamental. The constitution of the disciplinary committee, wherein the claimants union supposed to be in attendance. It's a very critical one. And the issue of fair hearing. Merely calling on the claimant to come in and it's on record she appeared. There was no record of the detailed deliberation that took place in that committee. So the defendant has a duty to fulfill that aspect. We still feel that it's not a mere irregularity where they fail to. Our position, the position of the defendant, is incurably bad, and I want the court to see it as such.
Okay, thank you.
Thank you, my lord.
Thank you, Mr. Chukuma.
Yes, my lord. May I
What
just
just
2
agree for
minutes on the new issues raised? On the new issues raised, my lord, may I just reply on the new issues raised? Just 2 minutes, my lord.
Yeah, what are they? What are the new issues?
One, the claimant was never charged. The claimant was charged with abandonment of duty and absence from duty without leave approval. I'm not for not failing to.
But you didn't you read
charge,
the issue of her refusal to get.
my lord, the charge on which the claimant, the defendant, on which the claimant was dismissed,
Yes.
specifically, is abandonment of duty and absence without leave approval. And these two charges are serious misconduct.
Not the issue of
punishable by dismissal. It's not punishable by termination and retirement.
What I'm saying is that he didn't charge her for her refusal to get redeployed. He didn't charge her for that.
Abandonment of duty and absence from duty without leave approval. These are the two charges.
Okay.
And they are considered serious misconduct, punishable by dismissal.
Yes.
My lord.
Where abandonment of duty
and absence from duty without leave approval.
Okay.
This is, I think, is chapter 4.4.2.2 and 4.4.2.3.
Absence from
the charge
without approval.
Leave approval. That is the charge, my lord.
Under which clause?
Chapter, I believe it's chapter.
If you are not sure, just
chapter 4.4, my lord. Chapter 4.4.2.3.
Yes.
And chapter 4.4.2.2.
Okay.
Yes, my lord.
Okay.
The two charges are considered serious misconduct, punishable by dismissal.
Okay.
She was not charged for any offense relating to termination and retirement. No, my lord.
No, but what about the issue of Mr. Chukuma?
Yes, my lord.
The issue of her refusal to get redeployed.
That is a top start. The main issue for her charge is at regards to these two charges.
Okay, but not that she refused to be redeployed.
Because we raised the point that there was a redeployment exercise, and that was why she did that. But the charge is for her because she abandoned her duty.
No, what I'm trying to say is that issue of her refusal to get redeployed.
Those are facts which we used to further strengthen the charges. The fact that she abandoned her duty post and she absented herself without leave is the charge before the.
Okay. How did she abandon her duty post?
My lord, she reported, made a handover, and was not seen anymore. That is abandoning of duty post, my lord.
But
she was redeployed to a new duty post. She handed over, did not report, and abandoned that duty.
Okay, that was the basis of her dismissal.
Of the charge for abandonment of duty.
Okay.
And absence without leave. And those are serious misconducts punishable by dismissal.
Are there two things or they are one thing?
There are two different things, my lord. Okay, as prescribed in paragraph chapter 4.4.2.2.
But that issue of abandonment of duty, I can remember that she said one of her directors asked her to stay around.
My lord, that is the other point I want to make.
Yes.
Leave matters under
Yes.
cross-examination here, leave matters, conveyance of leave matters is from the Department of Human Resources. The finance department cannot tell you. Leave matters are conveyed. It's in the staff conditions of service, my lord. It's even in the so-called paragraph that they are relying on.
But is it not the same organization? It is the same
No, sir.
organization. Yes.
No, sir.
If somebody is working,
if
somebody is working in one organization,
yes, my lord,
this department asks him to do something, and another department asks him to do a different thing.
Yes,
if there appears to be a conflicting instructions,
yes,
to the claimant,
yes,
can that be for the benefit of the of the claimant in case of any allegation that the claimant does anything wrong?
My lord, the conditions of service
be resolved is for his benefit.
My lord, the conditions of service are clear.
Yes.
And they have no ambiguity whatsoever.
Yeah. That
you apply to your direct boss, who sends it to the Department of Human Resources for conveyance. For conveyance.
Okay.
Yes, my lord. The third point is I want to draw my lord's attention.
But yes.
Yes, sir.
Yes, I can hear you, yes.
To chapter 10.2. Chapter 10.2.
Yes.
Which specifically says, because why I'm referring
annual
to
leave.
this.
Talking about annual leave, yes.
Yes, my lord. The claimant says there is a leave still running.
Yes.
As at 2014. And in reply, I state that chapter 10.2 of the staff conditions of service says all employees must take and exhaust their leave within that calendar year. So you cannot have a leave approval for 2013.
But then it's
considering, however, as at 2014.
But it's saying that the management may, with the consent of an employee, commence or defer the leave, but it should not be for more than 1 year.
If you do not exhaust it within that calendar year, it is still completed as at 1st February. So it was no leave.
This means that within that period, not exceeding 1 year, the management may, with the consent of an employee, defer the leave.
Yes, my lord. Yes,
but it should not be for more than 1 year.
As at 1st February, the leave is deemed forfeited.
No, I don't think that's
February 2014. That is the provision of chapter 10.2, my lord.
I say I don't think that's the proper interpretation. What I thought is that if somebody applies for his leave, say in November, and for that leave to end in say
in 2013.
January or February, because the leave has overlapped to the next year, isn't it?
Yes, my lord.
Yes, it has overlapped from 2023, 2024. So it means within, since it was to start from November and to end in February, then it means from
30-day leave. It's a 30-day leave.
I know.
30 calendar days, my lord. Annual leave is a 30 calendar day leave.
Yes, even if it's a 30,
exhausted within that calendar year.
Even if it is for 30 days, what I'm trying to say is that when your leave was to say commence in November or December.
Yes, my lord.
Then it means you can defy it up to within a year, up to the following year.
Yes, my lord.
For instance, if it were to commence in November 2013, you can also do it in November 2014.
No, my lord. No, my lord. If you don't defer or exhaust it within that calendar year, it is deemed forfeited as at 1st February 2014.
Okay. Then how are you going to define it? How are you going
That
to
is what I'm
define
saying. If you apply in 2013, for instance,
Yes.
November, and for
Yes.
circumstances you cannot
go.
exhaust it within that calendar year,
Yes.
you are
Yes.
to apply to defer it to any other time you wish to take. But you must,
Yes.
the provision says that leave, all employees must, it says must take and exhaust. Must take and exhaust.
Mr. Chukuma, that last sentence, which is saying the management may, with the consent of an employee.
Yes, my lord. Comment or defer, but it should not be for more than 1 year. But if my lord looks at the general, it says all employees must take and exhaust. So if you don't want to take and exhaust, that is when management, with your consent, can defer it, but not more than another year.
Yes.
That is the
It's okay.
position of chapter 10.2. So
It's
having
okay.
not taken and exhausted it within that calendar year, and having not deferred it within that calendar year, it is deemed forfeited as at 1st February 2014. That is the point. There is no pending 2013
but
leave. There is no running 2013 leave, as the claimants would like my lord to believe. There is no running 2013 leave, because it is deemed forfeited as at 1st February 2014. That is the position of chapter 10.2, and that settles this case, my lord. There is no running leave. It was not taken and exhausted within the calendar year. In contrary to the provisions, it was not deferred within the calendar year, and as at 1st February, it is deemed forfeited. That is the provision of chapter 10.2. And nothing can be added or subtracted.
Mr. Chukuma.
Yes, my lord.
Let me read this thing to you. It says,
yes, my lord.
Considering, however, that the maximum leave entitlement in a year is 30 days, 30 calendar days,
yes.
All staff should have exhausted their leave entitlement of a calendar year before 1st of February of the following year. That's under normal circumstance. Under normal circumstance, this means that you can start your leave on the 31st of December.
Yes, my lord.
Of the current year.
Yes, my lord.
It didn't exceed 1st of February the following year, isn't it?
Yes, my lord.
But it says the management may. So it means this is an exception to the above. May,
yes,
with the consent of an employee, commence or defer the leave, but it should not be for more than 1 year. It means it should not be for more than 1 year from the time that
thank you, my lord.
So it means
the provision also says management may.
We can do it. It means we can do it.
Discretionary.
It means you can
which
do
makes
it.
Discretionary. The management may.
It means you can do it. You can do it within the following year at any time you so wish. Within the following year.
No, my lord.
It's okay. It's okay. Are you done? So that we'll just adjourn. Mr. Chukuma, are you done? So that we'll just adjourn.
Yes, my lord. The third point, my lord. The third point that we are talking about, that she was coming during that leave period to attend promotions. My lord, it is in 2007 that the issue of promotion was made. She only brought it up in 2014, 7 years against the provisions of the staff conditions. With this, I urge my lord to dismiss this suit entirely.
Okay, thank you.
Thank you, my lord. My lord, I'm most grateful. Thank you for your indulgence. My lord, how is our Akwa Ibom State? How is Uyon?
It's okay, it's fine.
Okay, sir.
It's calm. It's calm.
Most grateful, my lord.
Thank you.
Thank you, my lord.
So I'm going to communicate once the document is ready, I will communicate it to you so that I will just deliver it. Hopefully before the end of this month.
As God pleases. Most obliged, my lord.
Thank you so much. So
thank you so much, my lord.
a date to be communicated to counsel for judgment via Zoom.
As God pleases.
Yes, Mr. Chukuma, how did you get the notice?
Lord, I can forward an email, I can forward WhatsApp, my phone number, anyhow.
Okay, you should forward it to.
We can do it here instead of
to our registrar Haja.
Yes, my lord.
That is the registrar Haja. You know her phone number now, isn't
yes,
it?
My lord. Yes,
and just
my
for
lord.
because when the link was sent to her, she said she couldn't find your phone number and the
yes,
email address.
I believe my learned senior colleague gave her my phone number.
Okay, Chief
yes.
Paul.
Yes,
okay.
Chief. Yes, sir. Yes, my lord.
Okay. It's like we have lost him, but it's no more here.
Yes, my lord. He's here, my lord.
Okay, Mr. Chief Paul will communicate that to you, please, for judgment. Okay, Mr. Chukuma, it's okay.
Yes, my lord. Thank you so much, my lord.
Thank you. Till then, thank you.
Thank you, my lord.
Okay. Aja, good afternoon.
Good afternoon, my lord.
Aja, are you still? Is the counsel for the second case, are they around? Okay, I can see Mr. Ambrose and the.
Yes, my lord. Counsel
okay, so
present.
This is 402-2018, ba?
Yes, my lord.
402-2018.
Yes, my lord.
Is the counsel for the claimant around?
My lord, I'm available. I'm in court.
Okay. Is your client in court?
No, my lord.
Okay, so parties absent.
We apologize for that. She's
okay.
in the state.
Parties absent, yes.
Parties absent.
Yes. Yes. Appearance.
With due regard, with due respect, my lord.
Yes.
Stella John, I humbly announce appearance for the claimant. Stella John.
John, yes. Okay, for the claimant.
For the claimant, my lord.
Yes. Yes, Mr.
This honorable court, A. Onyemakono. A initial Onyemakono is spelled on the screen.
Okay.
Yes, my lord.
Ambrose.
Ambrose, yes, my lord. I appear for the defendant.
Onye Makono for the defendant.
Yes, my lord.
Yes, Mr. Ambrose. Yes, Mr. Ambrose.
Yes, my lord. The matter is supposed to be for adoption of final addresses.
Yes.
We are ready to proceed, subject to the court's convenience.
Okay. Yes, Stella, you're also ready?
I'm ready, my lord.
Okay. Yes, Mr. Ambrose.
Yes, my lord. We did file a housekeeping motion to regularize. Yes, just to
Okay.
regularize our.
There is a pending motion.
Yes, it's a housekeeping motion, just to regularize our final address.
It's the one filed on the 18th of July,
Yes, my lord.
2022.
Yes, my lord. That's the motion. Seeks to regularize our final written address.
Okay. Yes, the motion is dated and filed.
Dated and filed 18 July 2022. In the absence of any opposition, we pray the court to move in terms
Okay.
of the motion paper and urge the court to grant the relief sought therein. We're very grateful.
Thank you. Yes, Stella, any objection?
No, my lord.
Okay. So defendant's application for extension of time to file its final written address dated and filed on the 18th of July 2022 is granted as spread.
As the court pleases, we're
As
very
the
grateful.
court pleases.
Yes, Mr. Ambrose, yes.
Yes, my lord. Lord, we have filed a final address dated
Yes.
the 18th day of July 2022 and filed
Okay.
on the same day. My lord, we adopt the said final address as our argument in support of our case and in urging the court to dismiss the case of the claimant in its entirety
Yes.
and uphold the defense of the defendant.
Yes.
It is in the interest of justice.
Yes. It's like you have also filed a reply, but there is a reply.
My lord,
There is a reply.
yes, my
filed
lord, we're
on-
going to wait for them to take care.
No.
Yes, we have a
Yes.
okay. Upon receipt of our
Uh-huh.
final address, the claimant did file their own address. So we, in response, filed a reply on points of law on 5th February 2024. Filed on 5th February, but dated, I think, 17th December 2023. Or filed on the 5th of February 2024.
Yes.
Yes, my lord. And we also adopt that and urged the court to rely on it as the more accurate statement of the law as it relates to the dispute between the parties. And to discountenance the erroneous position of law taken by the claimants in their own final address.
Yes.
My lord, the crux of the dispute between the parties is one that
Yes.
borders on wrongful dismissal.
Yes.
My lord, the defendant in this case has been overboard and complied with all its policies, the employment contract, the handbook, and
Yes.
all of the policies that bind it to the claimant. And
Yes.
after due compliance with those procedures, came to the conclusion that the claimant's conduct and involvement in the loss of about 2 point something million naira is such as to amount to gross misconduct and negligent and being a neglect of her duties. In our address, we have spent time to cite the relevant provisions that the defendant complied with in coming to that conclusion.
What was the claimant given any query in respect of that issue?
Yes, my lord. She was
And
given a query.
and there was a disciplinary. Is there any disciplinary panel
Yes,
constituted to?
yes, my lord. Both she was given a query. She responded to that query. And following her response, she was also invited to a disciplinary hearing.
Okay, following what? Okay, a response.
Yeah, following her response, she was also invited.
But in her response, she said that there was a computer something. The system, something was faulty on the computer. That is why the.
My lord, yes. The truth is that her conduct was, she was found wanting in two areas. The first is
Yes.
about the loss, the shortfall in her till, which indicates that there was some kind of fraudulent practices happening. And the second was that she had knowledge of that before she was even asked about it. And she did not take any step to escalate it to supervisors or superiors.
But she was saying that it was about somebody. Is this what's the name? Somebody.
Fabayo.
Yes.
Julius Fabayo.
Fabayo.
Yes. Yes.
That the police that put that money into her account.
My lord, yes, that was the position that she took. But when it was investigated, it was found to be not substantiated that was the case. And she has all the room, given her experience with the bank, to report any kind of fraud. It's her duty, as a matter of fact, to report such conduct to the defendant. And that was never done, not orally, not any. She alleged that she did it orally, but there was no way to prove that. So even if Mr. Fabayo, according to that case, was the one who is even culpable, the claimant in this case had knowledge of these occurrences before she was even.
And she was saying that there was a discrimination, that both of them were investigated, but while she was dismissed, but Julius Fabayo's appointment was, I think, terminated or something.
Terminated. My lord, we gave consideration to that issue in under paragraph 3.5 of our address, which spans page 13 to 14 of our final address. And
yes.
in those paragraphs, we took time to explain why the allegations of discrimination could not be substantiated. Key of which is Mr. Fabayo's indictment was failure to carry out effective supervisory duty on the claimant, that which led to the loss that is the crust of the matter. So he was indicted under a separate rule.
Okay, okay.
Yes,
Okay.
and it was terminated pursuant to, if I may just call the article 11.5. So
Okay.
it was not the
Even
same.
though
Yeah.
they were both investigation at the same time, but with different charges or different
Yes,
cases.
different cases for them. Yes, yes, my lord. That you just stated it accurately. Yes, they were for different offenses or
Okay.
different breach of the terms of employment. So the issue
Okay.
of discrimination and victimization did not arise in this case, and we
But
addressed
it's
that
like
very thoroughly.
they are saying that the you know a report of the investigation panel wasn't pleaded or wasn't front loaded. What were they saying?
Yes, yes. That was the allegation, and we addressed it in two ways. The first thing is that we said that was pleaded. That was the first thing. But the
The
second thing, it was
uh,
pleaded. And
okay,
that's
was
very
pleaded.
and that's very important, because the issue of front loading and no front loading is not in the Evidence Act. That's the truth. It's under the rules of court, and the Supreme Court has continuously held that once a document is pleaded and relevant, it should be admitted by the court. So
Okay.
we addressed that issue in our reply on points of law as well. And we cited cases of the Supreme Court saying that once a document has sufficiently complied with the requirements of the Evidence Act, the court should proceed to admit it and rely on it.
Okay,
So,
because the main essence of the pleading is not to take the other party by surprise. Once it's pleaded, the other party will be having the opportunity to react to it, even though it's not pleaded. Okay, it's not front loaded.
yes, because the thing is that you can only plead facts, you don't plead evidence. So
Okay,
if,
yes.
if there are facts to the effect that we carried out a disciplinary proceeding and we found you wanting, that's the fact that justifies the introduction of the report.
Okay, okay.
Yes.
Okay, it's okay. So, but what about the issue of, the defendant has alleged that it has, as a result of the alleged fraud, it has paid some of his customers so that the issue would not generate, public outcry, that it has paid some of his customers the money alleged to have been stolen by the claimant. I think you alleged 6 million naira or so. The 6 million naira was stolen.
My lord, the if I will recall the record is when the amount that I have in the address, though I'm referring to the address, is the shortfall of about 2 point something million. I will need to call up the pleadings to.
Yeah, because one of the arguments of the claimant was that you didn't tender any document showing, how you have paid your customers. You didn't tender any document showing this is what was stolen. I think it's one of the arguments of the claimant.
My lord,
Okay, in any case,
yeah.
what about this housing something? The claim of the claimant that her housing something was not, she couldn't access her account, and
Yes,
the defendant is
yes.
still
My
on.
lord, we also were able to address that issue in the written address. And on the first one about contribution to the Federal
Yes,
Mortgage Bank, that is the
yes,
NHF.
yes,
The way those funds are assessed is within the purview and the powers of the claimant herself. These are contributions that are made under the NHF Act, and it is meant to facilitate housing loans to employees. So
yes,
once you've been making such contributions, you will be entitled to have maybe a mortgage loan afforded you by the government through the Federal
yes,
Mortgage. The defendant has no say in how those monies are actually disbursed or utilized. The defendant's duty stops at remitting that sum to the.
And you have not remitted.
My lord,
Yes.
excuse me, my lord, so that in order not to waste the time of the court, these are no longer in issue anymore.
Okay, okay.
Yeah, they're no longer waste time of court.
Okay, it's no longer an issue.
If you look at our address, we said we are not going to comment because it has been addressed.
Okay, it's no longer an issue.
And at all.
So it means your relief number it
Yeah,
means your relief number G.
Relief number
number
under paragraph 2.1 of our address.
No, your relief in the main claim. That's you have reliefs A, B, C, D, E, F, G, H. H is saying that I'm directing the defendant to pay the claimant to. Okay, this is for annual leave.
Yes. She didn't proceed on leave for some 2 years due to exigency of duty.
Okay, you still want to pursue that?
It relieves I and J.
Due to exigency
of
duty.
Yes, I and J.
That's directing the defendant bank to set in motion relevant processes that will release to the claimants all the mandatory contributory funds, and an order directing the defendant bank to release and surrender. Okay.
No, they're no longer in issue, my lord.
Okay. Okay.
We settled them. We settled the 2 issues during the proceeding.
I learned that this matter. I learned that the PORs in this matter went on appeal, and the Court of Appeal affirmed the decision of
yes, after your learned brother gave an interlocutory judgment, Honorable Justice
statute of limitation.
Accepting jurisdiction.
No, it has been delivered, Mr. Ambrose.
When we went to the Court of Appeal,
in June this year, the Court of Appeal delivered a judgment.
No, Court of Appeal didn't deliver any judgment because
ruling on the issue of interlocutory appeal, isn't it?
No, there was no appeal. It didn't proceed to proper appeal. It was just a leave to appeal, which we stopped, asking the court to decline jurisdiction, and that was it.
No, what I was saying is that I saw one judgment of the Court of Appeal saying that affirming the decision of Honorable Justice Asian, that the Lagos State limitation law doesn't apply in contract of employment.
Well, the one I was in Court of Appeal, of which I was served a hearing notice, and they will challenge the court based on jurisdiction, and that was where we stopped. I'm now hearing this for the first time, because we said that they cannot proceed with hearing of that leave to appeal against the ruling of your learned brother, Honorable Justice Essien. And we challenged that process on ground of jurisdiction. And that was how we came back to the trial court and continued until we ended the case at the trial court.
If I may.
Okay, when was that?
Okay.
That was around 2019, 2020.
No, in June this year. In June this year, there was a decision of the Court of Appeal.
Well, I don't know. That means they didn't give me hearing notice. I don't know about that. I know about the one we attended around 2019, 2020, and I stopped the application from being heard at all because I was challenging the jurisdiction of the Court of Appeal. And of course, the extant law is that whenever an issue of jurisdiction is brought before a court, no other matter is taken until that issue question is addressed, and it was never addressed, and so we returned to the trial court. So this one, whether they got it behind my back, I don't know. I'm hearing this one for the first time.
Yeah, but they don't even get the judgment. The judgment was in the claimant's favor.
Okay, at the Court of Appeal?
Yes. Let me.
But it was behind my back. How come we didn't know about it? It was behind my back.
I don't know.
It was behind my back. But it's okay. We thank God it's in the claimant's favor.
I'm not sure that relates to this case.
Okay, no, I think it's related to. Let me
We are not aware of any such decision from the Court of Appeal.
Mm.
Yes. What we have at the Court of Appeal is a motion for leave to appeal the decision of the learned Justice, or the Honorable Justice ACN. We have not got a date for that. And the matter has not even come up since 2022. So to hear that, I don't think it may not apply exactly to this our own case. And the Court of Appeal on that issue has given conflicting decisions.
No, this decision was delivered in June this year.
That's why I'm shocked.
In June this year. Okay, let me get this thing for you. To deliver in June this year.
Because on that issue, your learned brother, Honorable Justice Kanye, has delivered a decision that to the effect that it does apply to that the employment contract are simple contracts. So that was sometime last year, if I recall correctly.
So delivered in June this year. Let me see. So delivered in June this year. You see, in Lillian Nena Akuma, is it the one?
Well. Very well, my lord.
Yes, Lillian Nena Akuma.
She's supposed to be the respondent at the appeal court.
Okay, let me see. Because the decision of Honorable Justice is that the limitation law of Lagos doesn't apply in contract of service. This was delivered on the
October 10,
2019. 2019.
Following the Supreme Court Johnson case.
Yes.
Supreme Court. So it was that decision that they applied for leave to appeal against at the trial court, but it still failed because of want of jurisdiction. So we returned to the trial court.
Okay.
So any which way, if there's any judgment of the Court of Appeal giving judgment to claimant.
Okay, sorry. It's a different case. It was delivered on 28th of June 2014, and it was in National Universities Commission and Kulero team. Sorry.
Okay. It's still the same legal principle being in controversy.
Yes.
And this judgment of your learned brother, October 10, 2019, has been the guiding principle of National Industrial Court ever since. Not only in Lagos, but in almost all the states in Nigeria.
Honorable Justice Kanye has deviated from that decision last year in a ruling.
But this was delivered in June this year. This Kule and National University Commission saying that the Lagos State Administration Law doesn't apply in contract of employment. It was delivered in June this year. And I think
even that judgment is made applicable to the 36 states and Federal Capital Territory. And that's why it's still selling in all the states. If you have been monitoring NIACN.
Okay. Let's get back to Mr. Ambrose. What do you want again? Do you want? Okay, so the claims Dian. Okay, when we come to take the defendants, claimants. will take note of this abandonment of reliefs I and J. Yes, Mr. Ambrose.
I and J.
It's like the claimant is
in the name.
Yes, the claimant is alleging that you didn't tender any document showing that this is the amount that was deposited in the claimant's account, and this is the amount that you have paid to your customers. I think that is one of the allegations of the claimant, that you didn't tender any document showing that you have paid something to your customers and that some money, was deposited into the claimant's account.
Okay, my lord, on those allegations,
yes,
the cost of the relief sought by the claimant is about wrongful dismissal.
Miscellaneous.
And in that case, what the court is required to do is to consult the Court of Employment to determine whether any provision was breached. And we have addressed the issue that none of those provisions were breached. So the issue of saying whether money was deposited as an argument or not, to me, it goes to almost no issue. We have not brought a counterclaim for those amounts. We are saying that we incurred a loss because of your conduct in the course of your employment. We investigated and found that indeed you were culpable. You could not satisfactorily explain away your involvement. And on the basis of that, proceeded with the process and then dismissed the claimant.
Yes, but some, even at that, if you're trying to allege that somebody has stolen some money from you, and you've also gone further to even pay your customers, don't you think that there's a need for you to tender the evidence showing that you have actually paid those customers, and that this is the document that is showing the amount of money or certain amount of money deposited in the claimant's account?
My lord, and I'll deviate a little, in cases where, for example, we are counterclaiming for those amounts, we tender those type of documents to substantiate a counterclaim for those sums.
Okay.
Yes, but as far as the present case is concerned, in order not to labor the courts, the issues are very narrow, and the issues are limited by what the claimant has inside of our claims. The reliefs circumscribes the claims of the claimant, and the reliefs that we were called upon to answer to was that of mainly wrongful dismissal or termination, which we properly addressed.
Okay.
In our address, the early address, and we made it very clear by the handbook and by the Court of Employment that the defendant did not in any way violate any requirements under the employment contract or even any provision of fair hearing. So the claimant received fair hearing and was eventually terminated. And on the issue of deposit into her account, the account was frozen. The claimant has self-admitted in a letter that she withdrew 500,000 from that account after the time she alleged that her account was frozen. So that was also not substantiated at all. She admitted.
But I thought that issue has to do with the issue of the mortgage.
No. She brought a relief that her account was frozen.
That's a relief number what?
This is okay. If I may just a moment to call up the
relief in the main 64E.
E, right? 54E.
And then in the alternative relief in the alternative.
But E is saying another direction the defendant to pay to the claimant all of her salaries and other entitlements due to the person of the claimant from August 24, 2007 to October 28, 2000, the period of frozen
and not access salary account. So, my lord, if I may come in, the fact is that The fact is that the claimant was recalled to duty.
Yes.
And there are evidence admitted as exhibits proving that, which are computer defendant bank generated. It was when she was recalled to duty that she had access to that account and withdrew 500,000 naira. But then they went after her, commanding her to submit. By then, she had spent 350,000 naira, and they commanded her under duress to transfer 150,000 naira to one of the dependent bank's officer.
Okay,
after
okay. When was
her account was closed till date.
When was the claimant dismissed?
She was
Claimant
dismissed
was dismissed on 2008.
October.
October 20, 2008, Exhibit C1.
Okay. So she wasn't given her money from August 2007 to the time she was dismissed.
No, she was given that.
It was before, when she was on suspension. To that time, she was dismissed.
Yes.
She didn't have access to her money and she didn't collect salary.
Okay.
So the claimant herself admitted that she was paid half salary in line with her employment contract.
What about the balance? What about the balance of the salary?
The claim, my lord, if I may address the issue.
She couldn't access her account. So if you didn't access your account, how do you not withdraw whatever salary?
No, but
my lord,
Mrs. Stella, did she, between the period of August 2007 to October 2008?
Yes, my lord.
Did she access her half salary?
She didn't, because the account was frozen. Her account and Julius Babaya's accounts were frozen.
Okay, so she didn't have...
the account of Babaya was opened. And then she brought an application appealing that her own also be open. But what is good for the goods is good for the gander.
What I'm saying is that when she was on suspension.
Yes, my lord.
Did she get her half salary even after the unfreezing of the account?
She did not, because she needed to access her account to get whatever money. She did not. It was only when she was recalled that she accessed and collected 500,000 naira, which I had painted the story. I don't want to go over it because of the time of the court. And after that, the accounts were closed till date.
And the claimant tender her statement of account showing that she didn't withdraw anything from August.
The closed account and as the date is as an exhibit before the court, my lord. I wish I could get, this case has a lot of exhibit.
Okay,
I think,
and it's showing that there was 2 million naira, 390,000 naira, which she didn't have access to.
The document speaks for itself, my lord.
No, I'm reading from your relief. Relief E is saying an order directing the defendant to pay to the claimant all her salaries and other entitlements due to the passing of the claimant from August 24, 2007 to October 28, 2008, the period of frozen and not accessible.
Yes, my lord. Yes, my lord.
The sum of 2,380,000. So what I'm saying is that this 2,300,000 and something thousand naira, is this a full salary or the half salary?
It's a yearly salary. What she claimed is a full salary.
Okay, it's a full salary.
Full salary for 1 year.
Okay, but this means that if the claimant, if the dismissal of the claimant is sustained, will she still be entitled to the full salary?
She will be entitled to the full salary as at the time from suspension to the time they dismiss her.
Yes, also, but when somebody is on suspension, only be entitled to
full
amount. My lord, I'm coming.
Okay.
And apart from that, even if she's not entitled to the full salary because she's no longer in the service, she's still entitled to some damages because of the wrong done to her. Because, I mean,
Mrs. Stella, what I'm trying to ask is, this your relief E is claiming for 2 million and something thousand naira. What I'm trying to know is that 2 million and something thousand, is it the full salary of the claimant or half salary?
No, it's the full salary, and she was still in the service. She had not been dismissed.
Okay, I'm coming.
She was still in the service from
So
the
this
time
2 million, this 2 million represents her full salary.
Yes,
but did she get the half salary?
She didn't get nothing because she didn't have access to her account. It was frozen. Julius Baba's account was also frozen.
Still frozen, but it's still frozen.
And it's still frozen till the day without court order, my lord.
Okay, so it means if somebody is, from the condition of service of the dependent, if somebody is under suspension, he'll only be entitled to a half salary, isn't it?
Yes.
So what I'm saying is that supposing the termination is sustained, it means the claimant will only be entitled to half salary between the period of 2008 to 2007, 2008. Not full salary.
According to the employee handbook.
Yes, according to
the employee handbook. Yes, my lord. But she didn't have half, she didn't have full, nothing.
And she still not having access to the
her annual salary for proper determination of her terminal benefits.
Yes.
By the bank.
By the bank, yes.
Where the court now rules in that favor.
Okay, Mr. Ambrose, what do you have to say about that, Mr. Ambrose?
Yes, it's two things. I think the two issues that have surfaced based on the submissions of the legal counsel to the claimant is one, issue of half of full salary. Yes. And the position is that the claimant assessed her half salary for the period she was on suspension. She was eventually dismissed, so she couldn't get the other half.
No, what I'm saying is that between that period, did she have access to a half salary?
No, my lord, he didn't have.
I'm asking him. I'm asking Mr. Ambrose.
Yes, my lord. Yes, my lord. Absolutely.
He had access to a half salary throughout the period of 2007, 2008.
Yes, my lord. August was not August to October. It's just 3 months we're talking about.
No, it's from. She's claiming from August 2007 to October 2008.
Yes, my lord. That's what we are saying. That in the period she was on suspension,
yes,
she was paid her half salary in line with the
But Irrelevant is she's saying is from August 24, 2007 to October 20th, 2008. What I'm saying is that the defendant proved that the claimant had access to a half salary during the suspension period.
Yes, and the key evidence justifying that was the claimant's own admission in a letter she wrote where she admitted that she withdrew 500,000 naira from her.
Yes, only 500,000 naira. Yes.
When she returned, when she was recalled from suspension, so that we don't mix up issues. My lord, salary checks, the claimant's salary checks during the period as rejected by the bank are also in evidence, is in exhibits.
Okay. In any case, Mr. Ambrose, are you done? Are you?
No, my lord. It's to point the court that that's Exhibit C13 on the record, and we took time to address some of these concerns in paragraphs 3.6 of our final address. We dwelled extensively on those.
Is it exhibit or what?
Sorry, Exhibit C13 is what I mentioned.
Exhibit C13.
What is it about, please?
Exhibit C13 is the letter that was written by the claimant solicitor admitting that the claimant withdrew the sum of 500,000 naira from her account. So that was
when she was recalled from suspension.
I will yield the floor. No problem, counsel. I will yield the floor so that I can land my points. We addressed those issues in detail under paragraph 3.6 of our written address, and it goes all the way down to 3.6 to 3.63. We talked about the issue of blockage of accounts, and then in paragraph 3.7, we also addressed the issue of the alleged failure of the claimant to access her accounts. And our position on that issue is that the claimant was able to access her accounts, and half of her entitlement that was due to her was paid throughout the period she was on suspension. Then there's another issue. The issue
Is that paragraph 3.6 to what?
3.7, my lord.
Okay.
Yes. Yes, we address the issue using evidence before the court, including Exhibit 13.
Okay.
Yes. Then the issue of terminal benefits, which the claimant has made heavy weather of. The simple response by law to the claimant is that terminal benefits are proven by evidence. They fall under the special of special damages. So anybody who alleges that they are entitled to terminal benefits is supposed to point the court to maybe the contract of employment or the policy that justifies the grant of such reliefs. In this case, the claimant has not alluded to even one policy or any term in her contract of employment that justifies the payment of the benefit she alleged. When she was terminated, she was paid her due entitlements by the defendant, and that's not in dispute. But this terminal benefit that is being referred to has not been substantiated by any provision of both the employment contract or the handbook. And the court is not for that Christmas. The court cannot manufacture terminal benefits for the claimant.
But the court can direct you to go and pay whatever the.
My lord, please.
My lord is addressing me, counsel. My lord is addressing me just so that the court. So we stay with the court.
Because it's another direction. Okay.
But the court.
Saying many things that are false. I have one brain, so I don't want to.
It's number F. Another directing the defendant bank to pay to the claimant all the arrears of her salaries and other entitlements due to the person of the claimant from October 21st, 2008 to the period of reinstatement at the rate of.
That is in the main.
Yes.
The reliefs are one in the main and in the
other. Relief is very problematic. And the reason it's problematic is on two scores. The first score is the one that I already had.
I'll go through that. I'll go through it. I'll go through it.
Yeah. My lord, if I may just add that.
Yes. My lord, the officer was dismissed.
The relief is faulty.
Dismissed any officer without
the first score.
Ms. Amber, what is
the first score? I will yield the floor, but let me just land this point.
Okay, please.
Yes,
if
I may, with all due respect, please.
Yes,
let me just yes. So the relief is here is faulty on two scores. The first score is that there is no substantial evidence presented for any kind of arrears, salaries, or terminal benefits. That's one. Number two, we all know the position of the law that you cannot reinstate. You couldn't reinstate. So asking for salary up to the point of reinstatement, that is another issue of law. You cannot force an employee on the employer. That is a settled principle.
It's okay.
Yes, and you cannot earn for periods you did not work.
It's okay. That is right.
Right. Yes, my lord. I need not even say it. Yes.
Yes, let's hear from Mrs. Stella. Yes, Mrs. Stella.
My lord, we have a final written address dated 12th August 2022 and filed same date.
It's dated 12th August
2022 and filed same date.
Yes.
Our release are also recaptured under paragraph 2021 particularly. And the reliefs are both in the main or in the alternative. So the court is expected to choose whichever one to uphold or to grant. And my lord, what got this suit is Exhibit C1, the letter of dismissal. Why we came to court was that the letter was just 2-line sentences. There was no reason adduced for dismissal. And the law is tried, and it's an international law. It's a law of international jurisprudence. That while you may not give reason for terminating an officer, you must give reason for dismissing an officer because it carries the stigma.
But the defendant gave their reason in their defense now.
I'm coming, my lord. So
Yes.
they didn't give reason in the letter, and even in the defense, when they now filed their statement of defense, they alleged fraud against the claimant, but they
Yes.
didn't plead particulars of the fraud. They
Okay.
also did not show that there was a concluded investigation with forensic report connecting the fraud directly with the claimant. It is not
Okay.
in that
The,
alongside with her was Julius Babayo, who was her supervisor in that branch of the bank.
yes.
And he made it so clear that being an inferior officer, she didn't have access to funds. She could only raise voucher, and then the man will countersign and release the money for her to deal with customers on the counter. She even went further to mention her own teller number and the teller number of the Julius Babayo. She also pleaded and front-loaded what they call vault in, vault out, where they could see the transactions that took place during the time of computer failure, because she kept hammering that it was during the computer failure that she started seeing irreconcilable. And she raised an alarm orally first before Julius Babaya. And she said the man did as if nothing was happening. And she took it to another officer outside the bank, and all reconciliation bids failed. And then she brought the matter to the headquarters orally. And they now gave her a query. She repeated the same thing, that it was during the computer failure that she began to see these strange figures. She even exhibited the vouchers that she raised, which her boss, Julia Dobaya, countersigned during that period. It's in the court as exhibit. And that same date, instead of seeing 85,000 naira, which she raised, she was now seeing another figure. That was when she raised an alarm. And that figure is quoted by Taylor. I think her boss is Taylor, Taylor 19. You know, why she was Taylor 18. And she went further to give notice to the bank to produce their staff files, so that the court will see who is teller 19 and who is teller 18, and look at that voucher, vault in, vault out, that display transactions of the court during the period, and see what teller 19 posted and what teller 18 posted, and the vouchers that she raised that are already before the court.
Yes.
So that's number one. Number two,
Okay.
the bank claims that there was an investigation. There was suspension of both parties. But there is no cogent material revealing the final report of that investigation, perhaps by internal auditors or external auditors, pointing the fraud to the claimant and as having benefited from that fraud. That particular report of final report was never pleaded, was never listed as one of the lists.
But Mr. Stella, let me read to you what the report is saying. The report is saying the chief internal auditor in his memo dated November 8, 2008 report was received from Alaba branch that one of the cashiers attached to their cash center suppressed cash and made fraudulent withdrawals from various customers' accounts through dry posting. It was reported that Ms. Akuma's mode of operation was to make withdrawals from a customer's account without vouchers and create the account of another pastor, James Eze Okoro, or take away the cash outrightly. Whenever Ms. Akuma received a complaint from any customer or observed that any customer she had tampered with, the account was around, she could quickly debit another customer's account or just credit the account without any cash. Hence, her till was gradually depleted until the fraud was uncovered on July 21st, 2007, when a cash shortage of 2 million naira was observed. Cash lodgements by some customers were also suppressed by her. Some were repaid in bulk or piecemeal, while others were still outstanding as at the time it was discovered. During the course of the investigation, Ms. Akuma's residence was searched and the police recovered lots of first bank vouchers belonging to customers, although also recovered were deposit vouchers which revealed that she made cash deposit into her brother's account at Union Bank and one Pastor Eze Okoro's account in Coca branch, totaling 1.7 million. The cash deposit made into Pastor Okoro's account were usually withdrawn at Coca branch a few minutes or hours after such deposits were posted by Ms. Akuma at Alaba agency. Ms. Akuma was the cashier who defrauded many customers. She was queried on her involvement and she confirmed that the stamp and the signature on the deposit vouchers were hers, but she could not tell or recall what happened. This is
My Lord, I believe you are reading Exhibit F, B, and 7A and B.
Yes, 7A and B, yes.
We want to remind this honorable court that that particular exhibit, the substance was never known by me, was never known by the claimant during the period of the disciplinary process or even during the period of the proceedings before this court.
Yes, but they are saying that
I'm just hearing this thing. What you have just read, I'm just hearing it for the first time. They are even in their pleadings, the bank themselves said they went to her house and discovered some bank customer vouchers. And they gave them a notice to produce those documents. Produce the documents to show that I by those vouchers I dealt inconsistently with the funds of the bank. Up to today, they didn't produce. What they are now saying in their reply, that it's left for her to come by a secondary evidence. How can she come when there are the people alleging that they saw papers and they carted away the papers, according to them, from her house? And she said, okay, bring the papers. She said, bring the papers. There are the people that are alleging. So they should prove it by those papers to the court. And not to just write something. All those things, my Lord, with due respect to the bank that you read, is just the same allegations against her, which were not even determined by requisite officer or external auditor during the disciplinary process.
Okay, but do you have this exhibit F?
Was never listed.
No, I'm not talking about exhibit 4A and B. 4A and B, which is the internal audit.
I'm hearing about it for the first time. Like that very day, she didn't disclose it to me.
No, I'm now talking about exhibit 4A and B, the internal audit, dated 15 February 2018.
15 February 2018?
Yes, 15 February, yes.
She has left the system. She left the system about more than 10 years ago. So if there should be any
No, not 2018, 2008. 2008.
2008. We are not aware of that document. She was never aware of that document. And the defendant never pleaded that document.
Okay.
They never pleaded any forensic report connecting that fraud or whatever fraud to the claimant. Because she kept asking, giving the notice to produce, and they didn't produce not one document. How can you allege that somebody stole your money and you cannot show you, and this is a banking transaction, you cannot show you by any document generated by the bank to find that this claimant at social time took away this money, dry posting and all that they are saying. And we in our report, we even showed what dry posting is. Dry posting is not even a criminal activity.
Okay.
We even started the glossary of bank in our report, our final written address. We plead with my Lord to take time to study our final written address.
No, not your final written address. You are pleading some evidence, not the final written address.
To be a report of 2008. Look at that paper.
Then that it's not your final written address that persuade me. It is your pleadings. But Mrs. Stella.
Yes, my Lord.
Let me refer to you the response of the claimant, Exhibit 3.
Exhibit 3.
Yes, FBN 3.
FBN 3.
Instead, I refer to a memo dated 25th July 2007 on the above subject matter and explain thus that this system balance of 2.8 million naira is as a result of the problem I had during last month computer network failure, which is yet to be resolved. During the period of the network failure, sometimes I will find my cash, my cash account in debit, sometimes in credit, and I will tell the Ojo manager, Mr. Favayo, J.O., who asked me to wait until the vouchers were finally posted. When network began to normalize, I sorted out all the processed vouchers. As I noticed this ambiguous balance, I immediately alerted Ojo manager again, and I went ahead. I went ahead to call over
vouchers.
I went ahead to call
over vouchers.
I've even had to go to the main branch, Alaba, but something. Okay, but sometimes in order to retrieve my vouchers again for all, so it's the claimant is admitting that there was money.
The argument we're making: if your officer you gave your officer a query and is pointing it against you, the institution, that is your own court, because he said they were doing upgrading. That was when this online banking started, and most banks were having issues with their online setups. And she now referred that it was during that time. She had worked with you people for 20 years, no one query, no report, no nothing. And she said it was that computer failure that she began to see the discrepancies. Is it not for the management to also check the computer, their system too, and be able to verify her claim? Because this is a very serious matter. The bank did not make any effort to engage their computer system, whoever that was responsible, so that to see whether this lady was lying. Is it actually the computer failure? This person has been with us for 20 years. We have never found her culpable for any misdemeanor or whatever. And now she has been queried and she's connecting it to our own computer system. Is it not for the management of the bank to check their computer system and be able to verify that claim first and foremost, before even calling in external auditors? They didn't do that, my lord.
Even as a result of the
fellow the only officer who was her boss.
Somebody's account can be created and debited.
The allegation is just a mere allegation. There's no real forensic report. From that to what you read, which I'm hearing for the first time.
What do you mean by forensic report?
There has to be some specialists like internal auditors or external auditors.
But there is a report from
my son is a chartered accountant. I know how these things operate. By the time they state it, you will now connect this to this person, connect this to this. It's so clear. There's no such. There's no such here. They just not good in that paper. They say it's a paper of 2008, but it's a very fresh, white, new, clean paper. There was no conclusive investigation, my lord. There was no report. And she was called, okay, if she was found culpable, why did they recall her to work? If she stole their money, why did they recall her to work?
When was she recalled to work?
She was recalled to work. Let me find out, my lord, from her pleading.
I don't know if it's my network that is the issue here. It's just breaking.
Yes, but we can hear you.
I'm hearing you.
Okay, it was breaking. You were breaking off, counsel. That's why I was wondering if it was me.
My lord, I'm trying to locate when she was recalled to work. We don't have light and well, I'm so hot here.
The issue came up when? The issue came up in 2007.
2007.
That is it's still in August.
She was recalled to work by a letter entitled Permanent Transfer, 2 letters dated September 19, 2008 and September 22, 2008. That is paragraph 33 of her amended statement of facts. Yeah, and it was after that report that she had access to that account for the first time. and withdrew 500,000 naira, which they came after her and they blocked that account for whatever reason still did. And we also tendered this letter, is in evidence. I don't know the number of the evidence, but my lord will check these two letters dated September 19, 2008 and September 2008. The letters recalling her from suspension. How do you recall somebody to work that you have seen that she has stolen your money? It's neither there nor there. I don't know what was in that FBN. The Mrs. Coker witness for the defendant did not show me. The claimant does not know the content. Even at that period, she was not shown anything that connecting her forensically to fraud. Nothing. She kept saying that the major culprit is Julius Babayo, but they let him go off the hook and then descended upon her.
Okay, I'll look at everything. It's okay. Look at everything.
Document that they said that she had to bring the government, a secondary document. She had given the notice to produce. They said they took away. They
Which
took away
document
the document. Let them bring the documents now to show that she
which
actually was stealing money.
Which document is that?
She's talking
The
about, my lord,
voucher
if I
that
may
they
come in.
claim they saw in her house.
Eh?
They
Talking
said
about
they
what?
came and searched her house and collected vouchers, customer vouchers in her
Police
house.
officers.
And the woman
Yeah,
said, okay, that she should now bring the vouchers that show that she collected money belonging
yes,
to the customer. They didn't bring any voucher.
Okay.
My lord, I will speak to that issue, if I may speak to that issue.
When are you?
two things.
You've already spoken, Mr. Ambrose. Now, yes, Mrs.
Yes, yes.
My
No,
lord.
Just to clarify that,
let
to
her
help
land.
the
Yes,
court. Okay,
let her
the court,
land.
please.
Yes, Mrs.
So
Stella.
that's it. So they cannot be asking the claimant to come by secondary evidence when they are the persons alleging. He who alleges.
Yes, I understand.
So, and another thing, they are alleging that she didn't cite any policy by which her terminal profits will be calculated. She has stated her annual salary
Okay.
for the year. And then
Yes.
she also made reference to her cadre. Let me mention her cadre. I'm coming, my lord. She said
you've already stated everything. I'll look at it.
she said she's on banking assistant 2 step 3, and that reference should be made to employee handbook page 51 paragraph 10.11 to enable the bank compute her terminal benefits. Her pay slips are also in evidence before the court. Her pay slips, so the court will even see how much she was earning. They are all before the court. Yes, and then for the money, my learned friend said that they paid her when she left. How can she be paid when she was dismissed? And they paid her during the time of suspension when she also put into evidence the salary checks that the bank rejected. The checks are before the court as exhibits. So how did they pay her? Apart from when she was recalled and she quickly had access, we do that 500,000 and they came after her after she had spent 350 and withdrew the 150,000. Where is the 150,000 naira? They paid into somebody's account, a staff account. Where is it? Have they given account of that 150,000? My lord, look at all the records. Her
Stella,
staff salary account remains closed since
Mrs. Stella.
2008.
Mrs. Stella.
My lord.
The claimant didn't get her half salary from 2007 to 2008, isn't it?
Didn't, because her account and Julia Babaya's account were frozen.
No, yes, but she only got the 500,000 naira.
That was when they recalled her to work.
Yes, that's what I'm saying. So that 500,000 naira was part of half salary. Okay, half salary on suspension.
Her money, she must have had other monies in the bank anyway.
Okay.
The fact is that immediately after that, they even wanted her to return the whole 500,000. But unfortunately for them, she had used 350. So then they asked her to return the balance of 150,000. After which they now closed the account till today without a court order.
Okay. It's okay.
Without a court order,
It's okay.
So it's dismissal without any reasons. There's no reasons spelled out on Exhibit C1, the letter of dismissal. There's no forensic report of the disciplinary investigation board. connecting fraud, because under sections 135, subsection 1 of Evidence Act, in any proceeding, whether civil or criminal, and there is a connotation of criminality, the onus is that the onus is upon the allegor to prove it beyond reasonable doubt. So those papers, my lord, with due respect to them that you were reading, you just see that main allegation they have been alleging. They have not been able to establish fraud against the claimant beyond reasonable doubt, as mandatorily demanded by Evidence Act. This is a general principle, a universal principle of law.
It's okay. It's okay. I've heard you.
The issue of discrimination, which offends ILO Convention, offends the Constitution.
You have said all that in your final written address.
Yes, my lord, we want to commend you to all our paragraphs in the final written address. We dealt with all the issues very succinctly, very clearly, in order not to confuse the court, because the defendant came by, putting before the court the reliefs sought under statement of facts, while she has an amended statement of fact. It's always good not to confuse the court. It was in my address that I now addressed the court that the amended statement of facts had superseded the statement of facts in respect to her reliefs.
Yes, it's okay.
And of course, she has to reply to her statement of defense, because in the statement of defense, it was when they even raised the issue of fraud and other things against her. And so we now reply so that we'll be able to lead evidence on those claims.
Yes, it's okay. It's okay.
So taking this TV service and just laid off like that.
Mr. Ambrose.
And then the Julius Baibaya was let off to hook. His account was even opened during that time. There's something we exhibited pleading with the bank to open her account as well.
Yes, Mr. Ambrose.
And my lord,
they claim in
their written aspect, my lord, excuse me, I've not finished, that Julius Babayo failed in his supervision duty. It was never pleaded in the statement of defense or the amended statement of defense. They didn't make reference to Julius Babayo at all. So we're even shocked that they're putting it into their final written address. They didn't make reference to Julius. It was the claimant that hammering on Julius Babayo.
And did you tender Mr. Fabayo's letter, termination letter?
How could she have a Babayo's termination letter? She gave notice to them.
No,
she gave a notice to bring
no,
it.
Mrs. Stella, you are alleging that there was a discrimination because Mr. Julius was only terminated. Did you tender his termination letter?
She don't have access to her termination letter. This was her boss.
This is didn't tender his termination letter. How do you want the court to believe that he was only terminated?
That should prove it. The bank will prove it. She gave the notice to bring his file. She gave the bank notice to bring the file so that the court will see everything. Why did they bring the file?
Okay, but you are the one alleging discrimination.
18, and the other one is Stella 19. And
you are the one alleging the termination. You are the one alleging that Mr. Julius was only terminated, not dismissed. But the claimant was rather terminated, rather dismissed. So if you are making that allegation, don't you think that you have a burden? Don't you think that you have a burden to
the bank? She cannot break into their vault now. She has told them to bring the file. This is court system. Everything should be open.
Yes, but I thought if somebody is alleging any discrimination, the burden is on him to prove that allegation of discrimination.
And she has proved it. They froze her account.
If you are saying that you have not been fairly treated, then don't you think that you have a burden to prove that by bringing all the relevant documents pertaining to the other person?
She proved and she cannot have access to the termination letter of her boss. And she doesn't have access to the file where they.
So if she can't have access to that,
proof that she made, she proved that her account remains frozen while that of Babayo was opened. Was unfrozen during that period. She was able to prove it.
And Mr. Fabayo's account was also tendered. I said, did you tender Mr. Fabayo's statement of account showing that his account was not frozen?
My Lord, now how can she have? Can somebody have my own account? Can you access my? Can anybody access my account and carry my statement?
Then if you can't do that, then why do you have to make that allegation? If you can't prove that, why do you have to make that allegation?
They did not deny it. They did not deny that allegation.
Okay.
They did not deny it in any of their pleadings. They just imported some arguments in the written address. They never denied it. They were silent on pleadings.
Let me clarify that point. The issue is
okay.
That,
so okay, Mr. Ambrose, there must be an end to litigation.
That point I want to clarify. It was not imported. A litigation, as the court pleases, is just to highlight a very salient point, for the benefit of the court and counsel on the other side, if the court will permit me.
What do you want to say? Because we have to call it a day, Mr.
Because sometimes you have to have grasp of the evidence first. But
Mr. Ambrose.
Yes, my lord.
There's one thing that I want to ask you.
Yeah.
When you gave the claimant a query, she responded and said that the money found on her account was a result of computer failure. Yes, can you hear me?
Yes, I hear you now, my lord. It was cracking
did you make any further investigation on that and come up with something that will debunk the allegation of the claimant that yes, the money found on her account was a result of the computer failure or not? Did you make any further investigation?
Nothing.
No, let him answer. Mr. Ambrose.
Yeah, I can hear you now, my lord, but network is not
what I'm
here.
trying to say is that when you gave the claimant a query, she answered that query. And sitting in a query that it's like somebody raising a defense in his in any allegation raised against him. She said that the reason why that money was found on her account was a result of computer failure. Did you make any investigation, further investigation about that computer failure to enable the court to say yes, or to debunk that allegation made by the claimant?
Okay. Oh yes, my lord. If I hear you correctly,
yes,
I had a glitch in my internet. You were asking whether there was investigation that was done to debunk her allegations.
Yes, she read the defense in her query, saying that the reason why that money was found on her account was as a result of computer failure. Did you make any further investigation to debunk that? Which is before the court?
Yes, my lord. Yes, my lord. The Exhibit 7, disciplinary.
Yes.
Now, when an employee makes such an allegation, the bank will investigate it holistically to know what exactly happened.
Yes.
And in this case, that investigation revealed that a technique that was used called dry posting that led to the loss that is being alleged. It didn't have to do with computer failure. And that's what the bank said in his pleadings and said in his disciplinary reports, that it was a technique that the claimant adopted to remove money from her own till and post it into another account that led to that shortfall, not trust of the outcome of the what communicated in that report, which is before the
My lord, check their pleading. They didn't make any reference to that computer failure. The defendant bank was carefully avoiding anything relating to computer failure, computer system. In all their pleading, there was no reference to computer system at all. There was none. I mean, the facts speak. The pleadings are there before the court. The amended statement of facts, our amended statement of facts. There was no reference by the defendant to computer system failure, because she said that the computer system failure was nationwide. This was nationwide, not only Lagos. I mean, that's a grave defense. that demanded.
So it was because of the computer failure that her account will today sometime be debated, another time it will be credited.
Yes, it was discovering irreconcilable through that computer failure, and eventually connected it to her board, Julius Babayo.
And you tendered that statement of account of the claimant showing that.
We tendered.
Yes, you tendered statement of account of the claimant showing that computer failure.
No, it won't have to do with the statement of account of the claimant.
No, but the money will be seen from on the statement of account of the claimant.
That irreconciliation didn't affect all the bank customer accounts.
No, I mean the claimant statement of account, because that money was seen in isn't it? On the claimant statement of account, isn't it?
It's not there now. It's before the court. It's in the court. We didn't hide it. I've forgotten the number of the exhibit. We didn't hide it. It's before the court.
It's okay. Let me just adjourn for judgment. Ms. Ambrose, can you hear us?
There's something I want to point out. They mentioned in their paragraph 2.2 of their reply, and they quoted one Yusuf Omagunda's case. That they say that we want to court to establish the guilt of the claimant. No, we want to court to insist that the defendant bank establishes fraud beyond reasonable doubt against the claimant. And that particular court, that case they cited, it has to do with whether an appellate court can interfere with the findings of a trial court. National Industrial Court of Nigeria was not sitting as an appellate court to reinvestigate what happened then in 2007, 2008.
No, what they are saying is that the once a disciplinary proceedings is conducted, what the court is going to look at is whether the claimant was given fair hearing. Not that
that's
whether
That's another issue entirely. Okay, if she was given fair hearing and they now connected the fraud to her, why did they become bold to state it in her C1? Letter of dismissal, exhibit C1. All of us had worked before. We know how these letters, I was an administrative officer, we know how these letters are couched. When you are terminated, we give you the reasons. We give you the reason.
What is, but they have stated the reasons in their pleadings now.
In the pleadings.
The reasons are stated in their pleadings.
The reason that there's no particulars of fraud pleaded. That's the general principle of law. If you allege fraud, you must plead the particulars of fraud.
Okay.
That's mandatory. There's no way to check their pleadings.
And in the pleadings, the fraud is not pleaded
at all. The particulars of fraud are not pleaded anywhere.
What do you mean particulars? You must see
Mr. Ambrose
first before you.
Yes, Mr. Ambrose.
Yes, my lord.
And we are going to adjourn for judgment to be communicated.
My lord, the written addresses are there for my lord to check through.
And they're there. I'll look at them.
We are sorry to really stress you out.
Okay. Yes.
So I wanted to raise was the issue of notice.
I'm not hearing
you. Of that issue.
I'm not hearing you. I'm not hearing you.
No, please, just forget about that, please. We should forget about that. Let's.
Yes, as a court, please.
We have the main issue, not the issue of notice to produce a section 1 something of the. So case is adjourned for judgment to a date to be communicated to parties. We'll communicate the date to you when it's ready, please. Maybe before the end of the month.
Please, we thank the court.
As the court pleases.
Thank you so much. I thank you.
My lord, I miss you.
We thank the court.
Thank you too.
My lord, I miss you.
I'm also missing Lagos.
You're not missing Stella John, I mean.
I'm missing the whole of Lagos.
Okay, thank you. I'm happy to see you once again.
My only issue is the traffic.
I will pray that the judgment date will not be long because this thing has.
It won't be long. I won't do it before the end of this month, so that we'll but I'm going to look at the issues that you've all raised and see.
Okay. I raised about 4 issues.
My main concern is the issue of when she was given the query, she answered and raised some things. That issue of computer failure, and the issue raised that you don't know about the investigation investigation report. So I'm going to look at all those things.
Exhibit FBI, no particulars of fraud, no forensic report. It was small.
No, but Mrs. Stella, if somebody is raising the issue of fraud in a workplace,
it was all those things you read that are just allegations.
This is different from from saying that somebody has committed an offense, because the level of standard of proof is different from what we are only going to look at is from the face of it. From the face of it, whether an employer has committed a misconduct or gross misconduct. We're talking about gross misconduct, not that somebody is guilty of an offense. No, whether he has committed a gross misconduct.
You're very correct. And even this court,
because
they ought to have even brought
as a banker, if money is found on your account, the employer has a right to question you on that. How do you get that money?
The account. They didn't produce her account and show to the court the money in issue that is in her account. The account is before the court, my lord.
Yeah,
it's even we that brought the account to court.
No, but she's not even disputing that. She's not disputing that, yes, there was some money on her account. But what she's saying is that it was as a result of a computer failure. That sometimes account will be debited, sometimes it will be credited. That's what she's saying.
It was issue of her till, my lord, not her account. But even if it's her account, not conceding, she brought her account to court, and the account is still in the custody of court. And the people that are alleging didn't even bring the account to show to us the money in the account that she put in her account.
Is it the till or her account? Mrs. Stella,
the way it works.
The bank that is alleging that brought the account. The her account. Show the millions in her account. The bank did not do so. It is we that we even brought the account to the court. So we're not.
No, what I'm saying is it her account or let me see the.
Yes, Mr. They made reference to her till.
Yes, my lord.
Yes. Yes, Mr. Ambrose.
Has a shortfall. That her till has a shortfall. They didn't make reference to her account, but she brought the account to enable the court to uncover everything and to know who to nail and who not to nail. She's not hiding anything.
The query says a review of your till. As of 24th July 2007, revealed a physical cash balance of 12 million so amount and the system balance of 2.8 million naira, give rise to a shortage of 2 million naira. You have to resolve this difference before the close of business today. You have to explain why you did not balance your till. What is this till?
Till is the money that's already left over.
I want to explain, my lord.
That they use.
Yes, Mr. Ambrose.
Check our written.
Let me explain it.
We explain the meaning of till.
Let me give to the court. If you are a teller in the bank, something that is like a dummy account that is called a till.
In
your votes. So while you are paying out money every day, so by the end of the day, your amount you paid out and the amount you receive must tally.
Yes.
It's like a dummy account that the teller operates for the purposes of their work. So you will receive physical cash that you keep in your drawer.
Okay, so physical cash.
The meaning of till is professional meaning of till.
Yes.
Container or drawer.
It's in our written address. You'll find the meaning of
it's a
till.
Container or drawer. It's not. It's different from vault. So it's a physical cash.
It's different from vault.
Yes.
Yes.
We get this in our final written address.
So what has the till got to do with the issue of computer? Because the till is a physical something, isn't it?
Yes, you get
My
a
lord,
you
my
get
lord,
an
our
amount.
paragraph.
Till is a physical something. If
Yes.
it's a physical something, then what has that got to do with computer failure? If you know, a physical cash will be found.
They asked her to, I don't know, I'm not a banker. You know, whatever you have must corroborate with. That's what they call balancing. Balances.
Yes, yes. The what I'm trying to say is that it means it doesn't.
Well.
It means it doesn't need to. It doesn't have anything to do with computer failure.
No. All of them, they connect to. They must agree. Both
How?
the computer and the cash must agree. I mean, that's the banking principle. Wherever there is a debit, there must be a credit. That's the banking. They must agree.
Till is a drawer or container where money is kept.
We refer you to paragraph on this till issue. We refer you to paragraph 4.4, 4.5, and 4.6 of our final written address on this till issue.
Yes.
So that we don't waste the court time. Paragraph 4.4, 4.5, 4.6. You know,
about the
final written address. You know,
the way it's supposed to work
it's a container or drawer where money is kept.
For cash.
Yes, cash.
My lord, he's not a banker. He's not a banker.
That drawer.
Yes.
I gave you 100,000 naira.
Yes.
And you must have 60,000 in your team.
Yes. Yes.
Whether there or not, you must have that amount in physical with you. What happened in this case was that the claimant still now claimed she had paid so and so amount, but when she was asked to substantiate it with her till, she had a shortfall.
Yes.
And that showed application. And that was why there was that. Showed that the claimant was using practices to take out money from the till, which created the shortfall.
I understand.
My lord, I referred to paragraph. So just read, my lord, please kindly read.
No, I now understand. It's even physical cash. They don't have anything to do with this account.
My lord, when you read paragraph 4.4, 4.5, 4.6, you understand what this till is and how it connects to computer, and why when she mentioned computer, the bank kept mum.
Okay.
Yes.
Okay. But does the till, does it have anything to do with computer?
Now everything must balance in the computer.
No, what I'm trying to say, this is physical. We're talking about physical cash flow.
Okay, if you give me, if I go to the bank and collect physical cash, wouldn't that physical cash having been withdrawn physically for me not be reflected in the computer ledger?
No, but the shortfall was found on the physical cash. In respect to the physical cash, not in.
That's what we are saying.
And she answered it professionally. She answered the query as a banking professional, and that was why the bank kept quiet. They didn't accost her on that. She answered the bank as the query as a banking professional. Take the letter to any banker. We say this person is a banker. He's a professional banker, and that was why the bank kept quiet till today. They kept mute. They don't make reference to that computer. They know what they are doing.
I understand that 3 weeks ago.
And Julius Mobile was her boss, the man was the main culprit. She showed everything on the vote in, vote out, vote vital to establish. She's the main for culprit. That's why she's alleging discrimination.
What did he do something? Mr. Julius Fabio, did he do anything? Did you commit any fraud?
Of course, she committed the fraud. Check the written address, all the documents we put in, you will see teller 18, teller 19. So you know who did what. I mean, the bank, all the allegations, they didn't bring anything. They went and brought allegation and named it a report of finding. Are we illiterate? We're not illiterate. It's just still allegations. It's not any finding. Forensically pointing fraud to the claimant. All of us have worked before. At least I'm not a small person. I've worked before. We know how these things go.
With a bank? Did you work with any bank?
I didn't work about, but I was an accountant. In an institution, yes. So I understand all these things.
So you understand money very, very well.
Yes. When you read my final written address, you will see the banking professional jargons. I was using in my final written.
I hope they're not going to confuse me. All the jargons will not confuse me.
So
in any case, I thank you so much. I appreciate you.
My Lord, also I appreciate the fact that she was there for 20 years and nothing, no query until that incident that involved her and her superior.
Issues are very narrow. It doesn't call for any kind of jargon.
It's
about
no. It's part of it. It's part of it. In investigation, investigate that. That's what they call first offender, second offender, third offender. I was an admin officer as well, you know. So,
Mr. Ambrose, why didn't you just terminate her instead of dismiss her?
Oh,
for somebody who had worked for about 4 years.
Why didn't you terminate her as you terminated Julius Babayo? Is it not discriminatory? When Julius Babayo was the main culprit.
My Lord, if I may respond to that,
when
we started the meeting, we highlighted that.
Please. I thank you so much. I appreciate you. I appreciate
all the arguments and all the court to.
We'll send the links to you
either in the mail or in the alternative.
When it's ready, your alternative.
My Lord, the reason why, and I want to address because he was not terminated because he violated sections of the punishment for such violations is termination.
Okay.
In those cases, aware of is dismissal.
Okay. I'll look at everything.
The bank knows that.
Okay, I'll look at everything now.
Because it's okay. It's meant for the sanctity of the banking system.
My Lord, just look at the
BM will mandate such offense to be
I look at everything. I look at the papers, the process file,
and all the exhibits.
I appreciate everything. I appreciate the arguments of the party, and I thank you so much. So let's call it a day.
Okay, sir.
In the absence of any other case, I wish to rise, and I thank you so much.
We thank you, sir.
So until then, thank you so much. Bye-bye.
Yes. Bye-bye.
Thank you.
Thank you very much for its very kind indulgence.
Thank you. Bye-bye. Bye.